Take a look at Act 1, Scene 1. It is in print, 2.5 pages long. Properly acted, it should take no more than 90 seconds. It is, well, it goes like that. There are incredibly funny things in it. There are patches of supreme poetry. It is intensely interesting, and at the end of the 90 seconds, you know all of the things you need to know that I've just touched upon in order to follow the rest of the play as it unfolds. Well, that's a master of playwriting at the top of his bent. When you deliver your next opening statement, it will not be the equivalent of Act 1, Scene 1 of Hamlet. Of course not. But for God's sakes, do it so that it's at least as good as a Kaufman and Hart exposition. What most of us tend to do, because our mothers taught us not to be self-assertive, is an exposition, a beginning of the opening statement that goes something like this. Good afternoon, ladies and gentlemen. My name is Irving Younger. I'm the attorney for the defendant in this case. You see why you don't want to push yourself forward. You don't want to be the opposite of self-effacing. Modesty is a great virtue in our society, and it is a great virtue. And nobody is more modest than I. On the other hand, when you're up in front of a jury, you've got a job to do. It's a performance that you're putting on. So deliver the exposition in such a way that the information sinks in. Here's a way. Of course, not the only way and far from the best. But let me do it, and I am going to annotate it. I'm going to stop every little while and tell you why I'm doing what I'm doing. Good afternoon, ladies and gentlemen. You know, we actually met yesterday when you were selected as the jury in this case. So I remember you, but I don't think you remember me. So let me reintroduce myself. My name is, stop. 10 seconds of empty talk. I have made no demands on the jury's intelligence at all. Done deliberately. You know why? Establish yourself. Give them a chance to let you sink in. This is me. Look at me. Listen to my voice. I am the most important person in this courtroom, yourself excluded, for the next 3 days. Make sure you know who I am. It's that kind of thing. My name is Irving Younger. Now, I'm a lawyer here in town. You've got to tell them you're a lawyer, even though you're going to get across the idea that it's by accident, we understand. I always call myself a lawyer. If I have to talk about him, he's an attorney. You know why? The word lawyer ends with ER, like baker, butcher, carpenter. It connotes an honest man doing an honest day's work. But attorney, shyster. You know, your ear hears it. Right? I'm a lawyer here in town, and as lawyers do, I talk for people. Never I represent clients. That's legal jargon. They're not quite sure what that means. We know what it means. They don't. I talk for people. And in this case, the man I talk for is sitting right there. His name is Jack Smith, and I'd like you to meet him. And in 9 cases out of 10, I will physically introduce my client. And if my client is a corporation, whoever it is who's going to sit with me gets introduced as if he were the client. Now, that's 9 cases out of 10. If you do criminal defense work, there'll be the 1 case out of 10 where your client cannot be introduced to the jury, because to see him is to know that he is guilty. So you do your best to hide him, obviously. Certainly don't emphasize it. But most of the time, the client is presentable or can be cleaned up so that he is presentable, and this is very carefully prepared with the client. You don't spring this on him by any means. And the idea is to introduce him as a fellow human being. So it's sitting here, his name is Jack Smith, and I'd like you to meet him. Jack, will you stand, please? If he looks younger than I do, I call him by his first name. If he looks older, it's Mr. Smith. Jack, would you stand, please? And he stands. And then I say, ladies and gentlemen, I'd like you to meet Jack Smith. And he's been prepared just to go like that. A slight nod of the head. And you know what happens? 6 or 12 people in the jury box nod back because their mothers taught them to do so, which is an acknowledgement deep down of the existence of a fellow human being. And it's going to be awfully hard, it begins to be a little bit hard for them to decide against him. They've embraced him. They've recognized him as a fellow mortal. Be seated, Jack. Thank you. Now, you don't do anything unthinkingly. But in many situations, you might now turn and introduce opposing counsel. Yes. Nothing that says you can't. Introduce him if that's what you want to get across to the jury, the idea that you're in charge of this courtroom. You know, I own it, the way DiMaggio owns center field. And this guy is here because I let him be here, and I'd like you to meet him. Now, one of the things that you consider in deciding whether to introduce him is that while he is helpless before the jury, he will not be helpless in the corridor, and he may have some things to say to you. So be ready that, you know, with some kind of a response. Let me give you some idea of what I mean by helpless. Now, ladies and gentlemen, I'd like you to meet the attorney for the defendant. He's one of the finest attorneys in this city. It's a privilege to be trying a case against him. William Green. Bill, would you stand, please? See? He must stand. He must. Ladies and gentlemen, it's Bill Green. Now, what's he going to do in front of the jury except... And I like the hand gestures because it conveys the impression of the puppeteer pulling the strings. Bill, ladies and gentlemen of the jury, Bill Green. Thank you, Bill. Be seated. I have in my time introduced his client, not in a criminal case to be sure, but in a civil case, yes. I have about half the time introduced the court reporter. It's a wonderful thing to do because nobody ever pays attention to the court reporter. Introduce the court reporter only with her permission. I use her because most of the time it's a woman in New York. Yeah, she's the one person in the courtroom you don't want to rub the wrong way. Ask her if it's all right. About half the time she says, hey, that's neat. Nobody ever introduces me. Sure, it's all right. And you see how wonderful it is. There you are, as the master of ceremonies, introducing the jury to another neutral person in this trial. So you know, there's a real feeling of kinship, and you can really do something with it. Now, ladies and gentlemen, do you see this lady? This is Mrs. Smith. She is the best court reporter in this courthouse, and believe it or not, with those 3 fingers of hers on that little black machine, she is taking down every syllable that I am now saying, and she will take down every syllable that is said in the course of this trial. I'd like you to meet her. Now, she can't stand up and say hello because she's taking it down right now, exactly what we're saying. She's taking down. But I'd like you to meet her. Ladies and gentlemen, Mrs. Smith. And they all go, hi, 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 you know, and Mrs. Smith nods. And I will not resist the temptation to tell you about my masterpiece in the line of introductions. Once, only once did I ever do it, but I figured I could get away with it. We had selected the jury, and His Honor had sat there throughout the jury selection like the toad on a log he was. He had not so much as told the jurors his name. So I figured, aha, if I can get away with this, the case is won. After introducing the court reporter, I took a deep breath, and I said, ladies and gentlemen, best of all, I'd like you to meet the jurist who will preside over this case. I assume you all know that any time a lawyer calls a judge a jurist, it means that the guy has no measurable IQ, none whatsoever. It's part of the code that we lawyers use, you know. And when an appellate court says of the trial judge, the learned jurist below, what it means is we read it in the record, but we don't believe it. That's always the usage. You watch that. In any event, ladies and gentlemen of the jury, I'd like you to meet the jurist who will preside over this trial. It is an honor to be working before him. There's no lawyer in this city who wouldn't want to be here right now trying a case before Judge Smith. Ladies and gentlemen, Judge Smith. And I held my breath. And the guy looked up and nodded and went back to whatever he was doing, and I figured that was it. I had established myself in that courtroom. And you know who I was? I was the head waiter. That's who I was. And if you think that that's not a very important thing to be, the next time you go to a fancy restaurant where there's a head waiter, observe what happens. The head waiter says to you, sit there. And what do? You sit there. And that's exactly what I'm going to tell this jury to do at the end of the trial, to decide it in a certain way, and they've already begun to be conditioned to doing exactly what I tell them to do. All right, so much for the preliminaries. Now let's get to what I said was my view of the secret for delivering the opening statement that persuades, but never once invites the objection that you are arguing. I get at it not with an analogy, I suppose we'd say, but something more nearly like an equivalence. Just listen for 30 seconds, and I think I'll be able to get my idea across, and then you decide whether you think it's worth it. What's the purpose of a trial? Well, we all know that. The purpose of a trial is to resolve a dispute, civil, criminal, whatever its nature. Underlying every trial is a dispute generated by some aspect of human affairs, and that dispute must be resolved. Obvious enough. Think back to the 6th or 7th grade. There came a day in the 6th or the 7th grade when your English teacher said, "Class, your homework assignment tonight is a little bit different from what it's ever been. Your assignment tonight is to write not an essay about what I did last summer, but a story. It's your first attempt at writing a story. Any kind of story you want. Bring it back tomorrow and we'll see what happens." So you went home and you wrote the story. And then you delivered it to the teacher, and a couple of days later it came back, and the teacher's comments written on that attempt at a story probably went something like this. Spelling, A. Grammar, A. Penmanship, A. Effort, A. As a story, D. Why? Well, that was the point of the exercise. The teacher wanted you to learn something about the nature of narrative art. That's not what you called it in the 6th grade, but that's what it is. It is something every literary critic, every student of literature knows. Given a literary form that involves narrative, short story, novel, epic, drama, you must have a conflict at the basis of it, at the bottom of it. Some kind of conflict generated by human beings living together. And what the teacher probably wrote on the paper to explain the D for execution is that you must learn that you need a conflict to have a story. And what you have written is an anecdote involving no conflict at all. So it's a prose sketch, an essay of some kind, but not a story. I don't know that it's the first, but among the first. You go right back to the Iliad. You know, Achilles is skulking because he's annoyed because he didn't get to keep the slave girl that he regarded as his trophy in consequence of the battle won against the Trojans. There's the conflict, and everything unfolds from that. The Odyssey, next in line, Odysseus has to get home. That's the conflict, various sub-conflicts along the way. Perhaps your taste runs to Genesis, right? Within 1,000 words of Bereshis Bara, the first 2 words, in the beginning, what's happened? God says to Adam and Eve, "Of that tree ye shall not eat." So they eat. There's the conflict. And it's been conflict ever since. Huh? Conflict is a synonym for dispute. If conflict underlies every kind of narrative, and conflict means the same thing as dispute, and dispute is presupposed by every trial, there is my equivalence. Within every lawsuit, without exception, no matter the jurisdiction and no matter its nature, there lies a story of some kind. A story involving human beings engaged in some aspect of human life. Sometimes the story is right there on the surface. All you have to do is bend down and pick it up. We all saw the movie Kramer against Kramer. If you're trying that case, the story is perfectly obvious. The husband, wife, etc., etc. If you're trying United States against IBM, you know, the great antitrust case now in its 7th year of trial, non-jury before Judge Adelstein, even in that kind of case, there is a story, not lying on the surface waiting to be picked up, but it's a challenge to your skill and creativity as a lawyer to find the story. And once you have found the story, and remember, in a way it's harder than being a novelist or a short story writer because you can't invent it. You've got to piece it together out of the evidence that you have. Those are the foul lines within which you have to stay. Once you have found the story, do you know what you do with it? You tell it to the jury in your opening statement. Your opening statement consists of telling the jury the story of your case. You realize all you're doing is telling them what you're going to prove, but you're telling it in a more or less artful way. Never once will the judge sustain the objection that you're arguing because you are not arguing. And do you realize what you can do with a story? Now to the real purpose of an opening statement, persuading the jury. It is the nature of the human nervous system, and also part of the miracle of literary art, that properly told, a story can make the audience do anything the storyteller wants the audience to do. You all know that. And if you need to be reminded of it, take out your library card and go to the library and reread some of the masters of storytelling, all of whose work is arrayed for you there on the shelf. And it's part of your obligation as a trial lawyer to read that stuff because of what it helps you to do as a trial lawyer, specifically with respect to the opening statement. You know that. If Mark Twain wants you to laugh, he tells you a story and you laugh. And if Chekhov wants you to cry, you cry. And if Tolstoy wants you to experience a religious conversion, by God, you will experience that religious conversion, just because of the way he tells the story. Not the only way and hardly the best way, but suppose we finish with the beginning, the introductions, the exposition. We're going to open in that intersection collision case in connection with which we wrote the trial memorandum a while ago. Ladies and gentlemen, if you had been standing on the corner of Main and Market Street here in town at about 10 a.m. on May 18th of last year, you would have seen a young man come out of the house that's right there on the corner. Parked in front of the house was a yellow Plymouth. He got behind the wheel, he had the keys, started the car. He moved away from the curb, and in a couple of seconds, he came to the intersection of Main and Market. Now, the light was green in his favor. He put his right turn signal on, and he began to make a right turn. Just stop. What do you feel? It's a simple enough kind of opening, but to some extent, every one of us is feeling, well, what happened next? You know, what went on? What occurred when he made that right turn? That's the nature of narrative. All of us are suckers for a story. You tell the story, you engage the jury's attention, and the art of it is to tell the story in such a way that the jury wants the story to conclude with the verdict you want them to render. But that's the only way they will be happy to conclude this story, with that kind of verdict. If that particular beginning of the middle of the opening sounded at all familiar, it should have, because you've all read it. When you go up to the attic to take out your Doyle to read The Adventure of the Greek Interpreter, right next to it, under the letter D, will be your high school copy of Dostoevsky's Crime and Punishment. You just heard the first paragraph. And I've used it many a time in opening statements. Years ago, I had occasion to reread it, and it dawned on me that the opening of Crime and Punishment is a marvelous narrative device. It's a kind of movie before movies were invented. On the morning of such and such an observer standing on the something prospect in St. Petersburg would have seen a young man come out of the building, and it's sort of the camera picking up this young man, and our curiosity is aroused at once. Who is he? Why are we looking at him? Why does the author want us to pay attention to him? What is he going to do? Well, ultimately, he commits a murder, and it's all terrific, and it's Raskolnikov, and it's great. And if it was good for Dostoevsky, it's good for you, let me assure you. So remember to tell the story. Okay. A couple of final points, and then we'll wrap it up. Let me get around here the right way. Never overtly argue. Of course not. Be honest with the jury. Never tell them you're going to prove something you don't expect to be able to prove. You can't get away with it. They will remember it. They will regard you as a four-flusher, and you're on your way to losing. If there are problems in the case that you have not yet faced up to them, face up to them in the opening statement. Lay them on the table. Tell the jury about them. Two points with respect to what you might do as an opponent. The other side is now opening. These are just for your consideration. Obviously, there's nothing hard and fast about this. First, my inclination is not to object during the other side's opening. A couple of reasons for that. We know you may. If you think the other guy is doing something he shouldn't do, you're entitled to object. I say no. First, the jury is conditioned to objections being made during the interrogation of a witness. They see that in the movies all the time. But when it comes to the opening, or again to the closing, they expect a smooth narrative flow uninterrupted by you, the opponent. If you do interrupt it, they tend to think that you're somehow hitting below the belt or that you're not playing the game the way it's supposed to be played. In any event, what is there to object to? Either he's arguing, so what? If it gets too bad, the judge will interrupt. Or he's telling the jury something you know he's not going to be able to prove. Fine. Write it down and deal with it in summation. That's much more effective than objecting to it during the opening statement. Second and final aspect. There is a motion, infrequently made, but permissible everywhere. It is another element of this unwritten law of procedure. Let me talk about the motion because, well, it's worth talking about. It is the motion for judgment on your opponent's opening statement. It's not codified anywhere, but it's authorized by a Supreme Court decision, the citation of which is in the pamphlet, but let me recite the citation anyway, because due to a quirk of the digesting system, it's very hard to find this case when you need it. It's called Best against the District of Columbia, and it's at 291 U.S. 411, 1934. 291 U.S. 411, 1934. The motion for judgment on the opening statement, and I saw some of you sort of nodding as if to say, what in heaven's name is that? If you've never heard of it, I can't blame you. It's very rare indeed. It's easier to enact than describe, so let me try to enact it. The other side has made an opening statement. We now ask for a sidebar conference, or we go into the robing room. It's not in the jury's presence, though of course it's on the record. And as the moving party, I would say something like this. Your Honor, Mr. Smith has just finished his opening statement. We all know the purpose of an opening statement, to outline for the jury what you intend to prove. For purposes of my present application, I concede that Mr. Smith will prove everything he has said in the opening statement. Having proved everything he said in the opening statement, he still won't have a case. See, it's like a demurrer. Assume it's all true, it doesn't state a claim. Assume he proves everything in the opening statement, he doesn't have a case. So, Your Honor, let's save time. Why bother with a trial? You're going to have to dismiss it at the end of the trial. Why don't you dismiss it now? And others of you are smiling, as if to say, will any judge in his right mind grant that motion? And the answer is, I have been told by lawyers all around the country of cases in which the motion has been granted. I don't mean to suggest there are hundreds of them or even tens of them, but there are cases scattered around the country in which judges have granted a motion to dismiss on the opponent's opening statement. I have never been before such a judge, and I assume you have no such judges. The judges before whom I practice would respond to my motion to dismiss on the other guy's opening statement with something like, Younger, will you cut it out? Very clever. You want a star to take home? Here's a star to take home. But for God's sakes, the day is long since past when we decide cases because of what may have been a simple misspeaking or accidental omission on the part of counsel. If we're going to dismiss it, it'll be because of a genuine failure of proof, not because the lawyer made some mistake. So sit down, your motion is denied. I will assume that that's going to be the judge's ruling. And I put it to you that there are still instances when you might want to consider making the motion. Now, I say it with trepidation because I don't like to think of lawyers trying cases this way. But still, my preference would be to try the case as if my opponent is not there. I leave him alone and he leaves me alone. But every once in a while, you run into an opponent who has been shoving you around. That is especially likely to happen when you are young and inexperienced, and, to mince no words about it, if you are a woman. What do? When you've got an opponent who has just gone over the line? It's been all elbows and knees under the basket. Well, to use language from another era, what you must do is let him taste your steel. And one way of doing it is to make that motion. He delivers his opening statement. Up to the sidebar we go. Your Honor, I assume it's all true. Assuming it's all true, he still doesn't have a case. Your Honor, I think you should dismiss it now. Now remember, I am assuming that the judge denies my motion. But remember, it takes the judge a couple of seconds to clear his throat and to get his thoughts organized so that he can deny my motion. Think of what goes through the other lawyer's mind in those 2 seconds. Something like this, I suppose. My God. How am I going to explain this to the client? I make a speech, and the judge throws out the case. At that point, the judge figures out what to say, and he says, Younger, will you cut it out? So my opponent says, oh, what a relief, my God. Right? And we go back to trying the case. For those of you who haven't been there yet, do you think he can go back to trying the case? No. Do you know what happened in the 2 seconds when he was saying to himself, my God, how am I going to explain this to my client? His adrenal glands opened up and pumped out into his blood system 5.5 gallons of pure adrenaline. Anybody who's ever been on the receiving end of that knows what it does to you. The adrenaline is Drano coursing through your veins, sapping away from the inside. And it doesn't disappear from your system the instant the judge says to the other guy, motion denied. It takes about 24 hours to wear off. And if you've ever had your system full of adrenaline, you know that when you get back to counsel table, your knees are going like this. You can't hold your hand steady. You can't think. You can't write. You are off balance the rest of the day. He has tasted your steel. Now, a perhaps more interesting question is whether you might want to do this even if he doesn't deserve to taste your steel. Just to shake him up a little bit. It is what I like to call Nastasi stuff, referring to the Romanian tennis player who misbehaves in heroic fashion on the tennis court. This is not the childish petulance of a John McEnroe. This is the guy, you've all seen him on television, who breaks tennis rackets across his knee and flings the pieces at the umpire, who has on occasion gone into the stand to slug a spectator who lies down on the court every so often and has temper tantrums. Why does he do it? Well, what the commentators say is that he's a hot-blooded Latin, because Romanians are Latins, after all. Nonsense. He's not a hot-blooded Latin, though he is a Latin. He's cool and calculated. He does it deliberately. There was no need when he was at the height of his powers. He was as good as anybody in the world. He's kind of over the hill now. But there's no need, except he wants to make money. And you make money if you win. And tennis, we all are duffers on the tennis court. We know that it's a game that requires enormous concentration. And if your opponent misbehaves in such a way as to prevent you from concentrating, you can't concentrate. Well, if tennis requires enormous concentration, how much more concentration is required when you try a case, which is much more difficult than playing tennis? And if one lawyer misbehaves, the other lawyer is put at a terrible disadvantage. And that's a rather troubling ethical question. This kind of misbehavior, it's not the kind of thing you get disbarred for. It's just sort of Nastasi stuff in the courtroom to prevent the other guy from concentrating, to break his stride, to put his rhythm off, to put him off his game. You want to play that way? There's no right or wrong. Everybody decides for himself, but if you're going to do it so that it works. And in a little while, I'll talk about some of the things that you might do or that might be done to you in connection with this Nastasi stuff. But first, the jury expects us to call a witness because the opening statements are over, and now the first witness will be called. Before we call the first witness, however, though the jury doesn't know about it, we know about it, there is a great deal of work to be done. This is a favorite topic of mine, and were time unlimited, I'd go on and on and on for hours. Time is obviously not unlimited, so let me tell you how I'm going to limit it. The topic is preparation of witnesses, but there are witnesses and witnesses. There are FBI agents, there are doctors, there are experts who've been in court a lot, there are experts who have not been in court a lot, etc. The one kind of witness I will talk about, and then only hitting the highlights, is John Q. Bystander. Remember him? The guy who happened to see the two cars collide. He is not an experienced witness. In fact, he's never been in court before in his life. He's never been a juror. He's never been a litigant. He happened to see the accident, and he will testify. Some aspects of preparing him. Now, principle number one. Whether it's John Q. Bystander or the most experienced witness in the world, you will never call a witness whom you have not prepared. Now, that is a rule to which there are only two exceptions. The first, unavoidable, So it's a can't help. The second, avoidable, shame on you if you let it happen. The first exception, unavoidable. The witness is the only witness there is to some fact which is essential to your case. You must call him, but he declines to speak to you. Well, if you're in private practice, you have no way of forcing him to speak to you. So you've got to put him on the stand without preparing him, and it's a terrible spot to be in. If you're the prosecutor, you do have ways of forcing him to speak to you. They are commonly called, the way is commonly called a grand jury. You just lay a grand jury subpoena on him and he talks to you in the grand jury. But that's specialized. Second, exceptional situation, and you should not let it happen to you. The judge tells you to have that we're going to resume at 2:15. You expect that at 2:15 you'll be ready to put this witness on the stand. You've been pressed for time. His testimony is not terribly elaborate. You tell him to meet you at 1 o'clock so that you can have lunch with him and prepare him over lunch. Somehow he gets lost. He doesn't show up. It's now 2:15. The judge takes the bench. He says, call your next witness. And at that very moment, the witness walks in. But you haven't prepared him because of the mix-up. Most of us are afraid of judges. And so we are reluctant to say to the judge, Your Honor, can I have a couple of minutes? I just need him to talk to the witness. Even though you're reluctant to do that, you must. And if you ask for it nicely, though the judge will give you a little Sturm und Drang, ultimately you'll get the couple of minutes. It is always a mistake to call the witness if you have not prepared him. Just one true story, briefly illustrating it. I prosecuted a case once in which the judge looked formidable, but was in fact a pussycat, except defense counsel did not know it. Defense counsel was afraid of the judge because of the judge's appearance. The judge took the bench at 2:15 and said to defense counsel, call your next witness. At that moment, the next witness walked in. For whatever reason, he had not come to court in time to permit defense counsel to prepare him. That next witness was, obviously to all of us, a character witness for the defendant in a criminal case. Counsel put him on the stand without preparing him. And verbatim, this was the direct examination. Sir, do you know the defendant? No. Well, do you know anybody who knows him? No. Have you ever heard of the defendant? No. Just kept saying no. At that point, the judge, who had a very good sense of humor, as well as being a pussycat, with a great gesture of that sort, said to the witness, Mr. Witness, thank you for coming to court and helping us, but you are now free to go home. And home he went. Well, that was comedy. More often, when you put a witness on the stand without preparing him, it's tragedy because it really blows up in your face. Don't ever do it. I've now said 5 or 6 times preparing a witness. In every jurisdiction, so far as I know, trial lawyers have a slang expression for preparing a witness. In many states, that expression is horse shedding the witness. And get the second vowel right. It's horse shed the witness. Referring to a house in which a horse lives, you take the witness out to that house and have a little talk with him. You horse shed the witness. In Michigan, they speak of sanding the witness, referring to sandpaper. In some other states, planing the witness, planing the splinters away. Whatever you call it, remember to do it. We'll assume that you've got John Q. Bystander there at the horse-shedding session. Some thoughts on how you might proceed. It'll take 5 or 10 minutes to discuss, but doing it may take hours or even days. First and foremost, I always assume that though John Q. Bystander cannot or will not admit it to me, he is going to be terrified beyond his capacity to describe and perhaps my capacity to imagine. His fright is infinite. He is in the grip of a cold, unreasoning hysteria. And that's very important to remember. When we go into court, you know how we feel. We're professionals at it. Some of us have done it 50 or 100 times before. Without exception, every one of us feels like throwing up. Truth to tell, sometimes we do. I know of cases in which the lawyer has thrown up in court, in front of the jury. Every one of us goes to the bathroom 5 times every morning of a trial, and it never goes away. And indeed, when it goes away, it's time to quit, because it just means that, the system isn't really psyched up for it. If we, the professionals, feel that, imagine what this guy feels. And part of it for him is that it's all unknown. Remember, he's never been involved in a courtroom before. Just think of one little aspect of it. You're asking him to come to the courthouse. A courthouse is a building that houses government. Whether his background is Eastern Europe, Western Europe, Northern Europe, or Southern Europe, he knows from his grandparents that if you walk into a building that houses government, you never come out. And that's true in the old world. In this blessed country, it's not true. You do come out, of course, but he doesn't really know that. He's got to be talked through the entire experience. That comes at the start, and it may take a half a day. You must think of everything you can think of to discuss with him, because he can't tell you what he wants discussed. He doesn't know. He's never done it before. The more you can talk about with him, not that his fright goes away, but the more effective the limit on it, so that the more he's familiar with it, the more focused the fright, and perhaps he can deal with it instead of the fright being absolutely inundating. So you want to talk about such things as, where's the courthouse? In New York City, it's impossible to find the courthouse. Even the cab driver doesn't know where the courthouse is. What you've got to do is ask him what subway he takes and actually talk him right through the streets up to the courthouse. When you get to the courthouse, John, how many lawyers in New York unthinkingly say, meet me in part 28? In New York, for some reason, they don't call courtrooms rooms, they call them parts. And they identify them by numbers. You're not going to believe this, but it's the gospel truth. The numbers are assigned at random, having no relationship to the place in the building where you find the courtroom. Yeah. So that if you're standing on the third floor of the Supreme Court, which is our superior court, and you're looking at three courtrooms, that one is part 19, this one is part 148, and that one is part 32. Nobody knows why. The clerk designates it by putting it on a cardboard and scotch taping it to the front door. Every Monday, they change all the numbers. And I don't know why. And finally, you know how they label it? You know, part 30, it's in Roman numerals. So that if it's above 10, most people can't read it. You tell him to meet you in part 89, and he's going to get lost, and he's going to starve to death before you find him. So what you do in New York is say, meet me at the cigar stand. See, there's only one of them. You can't miss it. No matter what happens, wait at the cigar stand. And now, just running through some of the things that you'll have to think about with him. When I meet, talk about it with him in advance. When I meet you at the cigar stand, we're going to go to the courtroom. You must know, so as to be in a position to describe to him, where he goes. Do you have a witness room, or does he wait in the courtroom? If it's a witness room, tell him he's going to sit in the witness room and then explain how he comes to be on the witness stand. Who's going to come and get him? What are they going to say? When he goes on the witness stand, you know what I have found they worry about inordinately? How do you take the oath? That's what they're worried about. So you'd better find out how they take the oath in your jurisdiction. I've had witnesses ask me, how do you take the oath? Do you go like this? Do you go like this? Do you go like this? What do you do? What do you do? And so you better know, so as to be able to rehearse with him how he takes the oath. Reassure him, as is true almost always, that it's an empty courtroom. John Q. Bystander thinks that every trial is the trial of Patty Hearst, with television cameras and reporters and whatnot. No. Explain, nobody's going to be there except the participants. The jury, I'm going to be there, the other lawyer's going to be there, the judge, that's the guy in the black bathrobe over here. That's all you have, right? Nothing much to worry about. And go through just as much as you can think of. After you have reviewed with him all of those clerical aspects, now you go to work on preparing the direct. And this is how I found it most productive to work on the direct. I would begin by saying something like, tell me what happened. And let him tell you in his own words. I would not take notes. The reason being something the social scientists call, I believe, the Whitman effect. If you take notes, he starts worrying about what you're taking notes about, and he's thinking about the notes you're taking instead of telling you the story, and it affects the way in which he communicates the information. So don't take notes. Don't use a tape recorder. That black box is a very formidable thing to John Q. Bystander. It will tongue-tie him. He finds it very difficult to speak into the tape recorder. What you've got to do is listen, concentrate, and remember as much as you can. You will discover, I assure you, that you can remember everything. Do your best not to interrupt. Let him tell it all to you in one take. If you're preparing the direct of the chairman of IBM in an antitrust case, obviously you can't do it that way. So what you do is break it down into segments and let him tell you all about that segment without interruption. After he completes his uninterrupted narrative, you go back having noted those parts that need work. And by need work, understand, I'm not talking of suborning perjury, of course not. I'm talking about those parts where his recollection is hazy, those parts in which the language he uses is not as effective as it might be. There are ways and ways of saying things, and not every way is as effective as the other. You go back and you work on those parts that need sharpening, alternative forms of expression, whatever it may be. And this may take another half day. And when it's all done, you now must make a very important decision. Should I Q&A it? You realize you have not yet turned it into questions and answers. Should you Q&A it? And let me tell you what I believe, and a number of very experienced trial lawyers, at least in my home area, pretty much agree with me, although many of you are going to find this astounding. Much of the time, the sensible thing to do seems to be forego Q&A. Don't rehearse it. You've taken him through it. You've gone back and cleaned up what needs cleaning up. But you don't cast it into the questions and answers that you will be asking in court in 48 hours. And here is the reason why. You are doing this in order to persuade the jury. What you want is a witness who comes across to that jury as sincere, credible, someone who is telling the truth. What you've got to do is get a sense of how Americans judge people. What is it that to an American in 1981 bespeaks sincerity and truth and honesty and telling the truth? Right, with that background, here's the problem with Q&Aing it. He is terrified, even though you've done your best to control the terror. He is the drowning man reaching out for any straw. If you Q&A it, do you know what he does? All unwittingly, but he does it. He memorizes the answers because he thinks that will keep him out of trouble. And just as you have a power to concentrate beyond your knowledge, he has a power to concentrate beyond his knowledge, and he'll end up memorizing most of his answers. And he thinks, that's terrific, nothing can go wrong. I know the answer by heart. All I have to do is recite it by rote on the witness stand. He takes the witness stand and recites it by rote, and I guarantee you the jury won't believe him. Because of the way Americans hear people. When I went to college, I spent an awful lot of time going to the movies. The kinds of movies I liked best were very bad movies. I don't like good movies. I only like bad movies. And the baddest of all bad movies were the kinds of science fiction movies that Hollywood used to make in the years before I went to college. This is not Close Encounters. This is not Star Trek. These are movies that cost about $1.76 to make, and they all were exactly the same. And many of you are old enough to have seen those movies, and I won't ask you to confess seeing them, but I know that you've seen them. 3/4 of the way through the movie, what's going on? You know what's going on. The formula's identical. There are 5 actors on the screen. 4 of them are Earthlings. The 5th is an alien being who has taken the form of an Earthling, and the job of the other 4 is to figure out which one of the 5 is the alien being and zap him with the laser gun before he takes over the world, right? You can walk into the theater in the middle of that scene. You have not seen the 1 hour of movie that precedes it, and you know which of the 5 is the alien. See, the 4 actors playing the Earthlings do not know, but we know. That is called dramatic irony. The audience knows, though the actors do not. And do you know how you know which one is the alien? Because of, I don't know what to call it, a convention that the filmmakers are familiar with and that you as trial lawyers must be familiar with. How do you know which one is the alien? Well, if many of you did not waste the flower of your youth going to such movies, so let me bring it up to date. Star Trek. There is nobody here who has not seen Star Trek, if not in the movies, then on television. There are 2 protagonists, Captain Kirk, an Earthling, and Mr. Spock, an alien being. How do you know that Mr. Spock is an alien being? 3 ways. He's got pointed ears. He's got a green complexion because his blood is based on copper, not iron. But the 3rd way is the most obvious. How do you know that he is an alien being? And the answer is, all alien beings speak perfect English. Captain Kirk is well spoken, but he does not speak perfect English. And you know, this applies to the ordinary acting. Take the actors, the Hollywood and the movie stars that we all know, who can only play good guys. Spencer Tracy, Jimmy Stewart, well spoken to be sure, but perfectly spoken, no. Take an actor who can only play bad guys. Vincent Price. You know who Vincent Price is? If you don't know, if I had a picture of him, you'd recognize him at once. He's getting on in years, but he's very busy, a very successful and very able actor. His voice is a drop of salad oil running down the stalk of celery. Every syllable is perfectly spoken. And the instant he opens his mouth, in any movie at all, you know that he's a homicidal maniac, because that's the way we listen to people. You put John Q. Bystander on the witness stand, Bystander having memorized his testimony, and you know what's going to happen. It's going to come out letter perfect. And in the ears, or to the ears of the jury, that bespeaks something other than credibility. They listen to this guy speaking perfectly, and they say to themselves, huh, listen to him. He's an alien being. And what you do with alien beings is zap them with the laser gun, of course. So the equivalent is you don't believe them. A very, very able trial lawyer in New York does it a little bit differently. What he does is Q&A the 3 or 4 crucial questions, just to be sure, and leaves everything else for extemporaneous Q&A in the courtroom, but for the same reasons, to give it the hallmark of spontaneity. And by the way, that applies to you as well as to the witness. If you Q&A it in advance, your questions will be letter perfect, and that's a danger. If you extemporize your questions, of course, every once in a while you get one of those questions and you can't make it come out right. You know, you just can't reach the question mark. So you know what you do. You say, Judge, I kind of screwed it up. Can I withdraw that and try it again? And the judge says, sure, go right ahead. And the jury loves it, so long as it doesn't happen too often. If it doesn't happen too often, it bespeaks not incompetence, it bespeaks a human being who makes mistakes like every other human being, instead of a cold and perfect lawyer. As a matter of fact, if you were to undertake to prepare John Q. Bystander and neglect to discuss with him what we will now discuss, he won't let you forget it. He will be tugging at your coattail and reminding you that you have forgotten. Forgotten what? Forgotten to prepare him for cross-examination. And I tell you that in John Q. Bystander's mind, that's the most formidable part of testifying. It's the Perry Mason syndrome. He understands that he will take the witness stand and on direct examination tell what he saw when the 2 cars came together at the intersection. And then on cross-examination, he will be made to admit committing the murder, because that's the way it happens in Perry Mason. He knows that he committed no murder. He knows that the case involves 2 cars that collided, and yet, who knows? Well, there are all kinds of ways of preparing the witness for cross-examination, and perhaps this is the simplest and therefore the most effective. I would suggest that you say to John Q. Bystander, listen, John, every lawyer conducts cross-examination in his or her own way. I cannot anticipate or predict what the other lawyer will ask you on cross-examination. Therefore, I can't really prepare you. But I know that you want to do well. I know that you don't want to be humiliated in public. I know that you want to do everything that you can consistent with what's required of you to help us to win. I can give you one piece of advice. And if you will follow that advice, there's nothing to be concerned with. You'll be pleased with your performance, and the case will come out as it should. And that advice, John, is this. On cross-examination, listen to the question, be sure you understand it, and when you do understand it, answer it with the truth. That is all you are to say, the truth. But John, you must continue. In a courtroom, the truth means what you know through one or more of your 5 senses, what you yourself saw, smelled, heard, touched, or tasted. It does not mean what you have figured out to be true. It doesn't mean what you surmise to be true. It doesn't mean what you sincerely believe to be true. It means only what you know to be true. He will nod and seem to have digested that. I urge you not to stop at that point. Continue as follows. Now, John, I can't forecast what the other lawyer will ask you on cross-examination. But if you want, I will cross-examine you myself right now. And his eyes will light up and he will say, oh, that's terrific. Okay, let's do that. And you say, all right, now do you understand? I am not Younger anymore. See, that's Younger sitting over there. He's finished his direct examination. I'm whoever, some other lawyer, and I am going to cross-examine you. He says, yeah, I understand that. Now, John, before we do it, tell me again, what's the one thing you have to remember? And he will say, tell the truth. You got it, you got it. That's the one thing you have to remember. Tell the truth, no matter what is asked. Let me hear it again. Tell the truth. Yep, sounds to me, once more, let me hear it. Tell the truth. Okay. You ready? Yeah. You sure? Yeah. I do. Before coming to court, did you discuss your testimony with Younger, sitting right over there? No, sir. Every time. Every time. And you must now stop and say, now, just a minute, John. What have we been doing for the last 2.5 days? Discussing our testimony. That's right. Why, then, did you say no when I asked you that question? And I am quoting the actual responses received from a certain John Q. bystander many years ago. He said, well, I'm not supposed to admit it, am I? And I said, of course you're supposed to admit it. The judge wouldn't believe you if you denied it. No lawyer puts a witness on the stand without preparing him. And then listen to this. I took a deep breath and I said, and whether or not you're supposed to admit it, isn't it the truth? Yeah. And didn't I tell you that no matter what is asked, you are to tell the truth? And listen to his response as a further insight into what the public thinks about lawyers. I said, didn't I tell you that whatever is asked, you're supposed to tell the truth? And he said, oh, you really mean it, huh? I said, yes, you son of a bitch, I do really mean it. Now, come on, you want to try it again? Yeah. Let me hear the one rule. Tell the truth. And I really mean it, right? Right. Okay, you ready? Yeah. You sure? Yeah. All right, you. Before coming to court, did you discuss your testimony with Younger sitting over there? Yes, sir. And did Younger tell you what to say on the witness stand? Yes, sir. Every time. Every time. So now you've got to go back. Now, wait a minute, wait a minute. What have I told you to say on the witness stand? Tell the truth. Right. So if the lawyer asks you that question, I guess that's your answer, huh? Yeah, I guess so. And now if it happens that way, it's going to come out, did you discuss your testimony? Yes. Did Younger tell you what to say? Sure. He told me to tell the truth. And the other lawyer instantly backs away. Not only because he's dealing with a witness who's been prepared, but because he now realizes that he's dealing with you, a lawyer who knows how to prepare a witness. Now, we've got to move on, except for one aspect of witness preparation that is almost always overlooked. I, too, overlooked it until the one experience I had that I will briefly tell you of, which brought home to me its importance. Shame on me, especially, for having missed this, because I think that the analogy between the courtroom and theater is awfully important. And any man or woman of the theater will tell you that costume is a crucial aspect of communication from the stage. We lawyers tend to forget the importance of costume, perhaps because it's really very difficult to direct someone what to wear. You can direct yourself what to wear, and were time unlimited, I could go on for at least 2 hours on what a lawyer should wear. But I don't want to talk about what a lawyer should wear. I want to talk about the importance of remembering to say something to John Q. bystander about his costume on the day of trial. By costume, I mean however he's going to dress himself. If you don't say anything, he gets up in the morning, he stands in front of his closet, he says, all right, I got to wear something. Now, what do I wear? Well, it's court, so it's formal. But what kind of formality? There's the formality of a wedding, there's the formality of a funeral, and they are not the same thing. You've got to give him a couple of words of advice so that he knows what to wear. Here's my experience, brought it home. Years ago, before I went on the bench, when I was still in practice, one of the clients that I had was a national firm of supermarkets, and what I did for them was fly around in their company jet from city to city, losing slip and fall cases for them. Okay, that was my job. And you all know what a slip and fall case is. The lady walks into the supermarket, bang, she slips on the lettuce leaf, or so she says. There is no way to prove that she didn't slip on the lettuce leaf. She certainly has a fractured ankle or something of that kind. And, you know, well, how can you defend it? On liability, you say, well, I guess she slipped. We sweep up every 30 minutes. And if that's not often enough, so I guess we're liable. But you're going to have to pay for the extra sweep up in the form of increased prices. Or maybe you try to keep the damages down. Well, on this occasion, I jetted into a city not very far from here, and we were going to try to contest liability. And the only witness was the kid who sweeps up. And lest anybody think ill of me, that is a term of art in the supermarket business. It doesn't matter how old the person is, and it doesn't matter what his or her gender. It's the kid who sweeps up. And his testimony was going to be, I swept up at 10 a.m., I was going to sweep up at 10:30, but she fell at 10:15. That's all I know. I went to the supermarket and was introduced to the kid, and he was wearing the white smock smeared with cabbage juice. You know, we know the getup. And we went across the street to have a cup of coffee, and we talked for about 15 minutes, very bright, very able to express himself. And after 15 minutes, I figured he was ready. And I said, I'll see you in court tomorrow morning, and that's your testimony. I swept up at 10. I would have swept up at 10:30. She fell at 10:15. I neglected to tell him what to wear. He came to court the following morning, obviously having stood in front of his closet and having said to himself, I guess I dress formally. He was wearing a Brooks Brothers three-piece suit. Across the front of the vest, a gold watch chain, and dangling from the watch chain, a Phi Beta Kappa key. Said I to him, said I, where'd you get that? And he replied, Princeton. And I said, what are you doing? Sweeping up in a supermarket. And remember the times, you know, way back then. His reply, rather winningly, was, well, I'm getting my head together. Wonderful. Just wonderful, right? A parent's pride and joy. He gets out of college, and instead of hitting the drug scene, or Haight-Ashbury or something like that, he works, you know, it's humble, but it's honest work for a couple of years, and then he'll probably get himself together, and for all I know, he went on to law school. I put him on the witness stand, however, and do you see the importance of theater and not coming across as phony to the jury? His testimony, his lines were what? I'm the kid who sweeps up. His costume was what? I'm an assistant professor of history at Yale. There is a disparity between the two, which comes across to the jury as phony. And they told me so in no uncertain terms in the verdict. So remember to spend at least a moment or two discussing the importance of costume with the witness. Well, and that's all that we can devote to witness preparation. The other major topic that we've got to talk at least a little bit about before getting to direct examination is something which has many, many facets. And I'm only going to talk, I think, about two of those facets, maybe three, for the rest leaving it for your leisured reading in the pamphlet. I forget what we call it there. Preparation for trial. Positioning the case for trial. Not preparing the witness. We've already said what we can have say, given the time, about that. But other aspects, right? Most important aspect and the first to be discussed. I have already stated my belief that in every lawsuit, whether it's on the surface or hidden, is some kind of story, a story of human beings in conflict. Think back now, not to the 6th or the 7th grade, but perhaps the 2nd or 3rd year of high school, maybe even the beginning of college. Everybody took, if only because you were required to take, a course in literature. In that course, you had to have been subjected to lecture and perhaps some writing on the mystical effect in literature of the theme, the idea which serves to unify the work of art, the work of narrative art, be it novel, short story, epic, or drama. The theme is always very simple if you pull it out of the work and state it separately. It is so simple that when you do state it separately, you tend to laugh because of the contrast between the complexity of the embodiment of the theme in the finished work of art and the almost absurd simplicity of the theme when you state it. It is for that reason that the artist will never state the theme separately. And indeed, that can be turned into comedy. Do you remember the frontispiece of Huck Finn by Tom Sawyer? Anybody attempting to find a theme will be shot. Right, that gets rid of it. But of course there's a theme. Right? And there's a theme to Hamlet, and there's a theme to the Iliad, and there's a theme to the Odyssey, and there's a theme to a Chekhov story, and there is a theme to every major work of art. What the theme does for the artist, and all you can do is kind of state it and admire it. It's ultimately mysterious because all art is a mystery. What the theme does for the artist is to unify the telling of the story. And to the extent that the artist gives the story unity, somehow the effect upon the audience is enhanced. It is for that reason, as every good artist knows, that once you have the theme, you must let it do the job of unification for you. And if a wonderful character or turn of plot or scene occurs to you, but that character or turn of plot or scene is unrelated to the theme, you must excise it, take it out, put it in your notebook and save it for your next novel. But don't put it in this novel because, as every artist knows, to the extent that you include material unrelated to the theme, you detract from the aesthetic effect. Exactly the same is true of a trial. Your trial must have a theme, the central idea that gives unity to the story you will unfold in the drama that you present to this jury. And for you, the trial lawyer, as for the literary artist, you must let the theme do its job. Every witness, every exhibit, every bit of testimony must have a relationship to the theme. And if you've got a witness whose testimony seems in the abstract kind of helpful, but it's not related to the theme, don't put the witness on. If you do, we trial lawyers call it over-trying the case, sometimes called the kitchen sink approach. Put everything in without having the self-confidence to discriminate between what's relevant to your theme and what's irrelevant to your theme. To the extent that you present a case in which everything you do for that jury has an articulable relationship to the theme, somehow you enhance the likelihood of achieving the effect that you want, and that effect being one of persuasion. And do you know where the theme first appears in the course of the trial? You should know, because I've told you. It's the second sentence of the first paragraph of your trial memorandum. Remember, the first sentence of the first paragraph in plain English tells the judge what the case is about. This is an action for personal injuries and property damage arising from a collision intersection, blah, blah, blah. Second sentence, tell the judge your position. What was the example we used? It is the plaintiff's position that the collision occurred because the defendant failed to stop for a red light. That's the theme. It happened because the defendant failed to stop for a red light. And the only evidence you will put in is evidence which bears upon that theme. If you've got a witness who can testify to the effect that before getting behind the wheel he'd had a couple of beers, don't call the witness, because that witness does not tell you something that's related to the theme. If you call that witness, you're diffusing your presentation. If you want to consider calling that witness, consider changing the theme. It is the plaintiff's position that the collision occurred because the driver of the blue Buick was driving while intoxicated. That's a different theme. That gives the case a different posture. And so there's no one way to present the theme. There's within the foul lines, there's creativity. You've got to think about what's possible, what's going to make the best impression, where can you make use of the best witnesses, et cetera, et cetera. But once you've got the theme, Remember, it's a principle of exclusion. It tells you essentially what not to put in. And what you don't put in is anything that's not related to that theme. Second aspect of witness preparation. Many lawyers who are meticulous in preparing opening, summation, direct, cross, pay no attention to what the jurors see when the jurors look over at you and you're not doing anything. It's your opponent who's doing something. For example, it's your opponent who's now summing up, final statement to the jury. He's doing a good job. Nothing to object to. You just sit there. As you sit there, you constantly remind yourself, at any given moment of the trial, at least one juror is looking at you. And do you know why that is so? Jurors have different attention spans, but the attention spans that the jurors have are the attention spans that human beings have. And, you know, we all know that a typical adult normal attention span is about 2 minutes. A 5-year-old infant has a 30-second attention span. Part of growing up is lengthening the attention span. And if you've got an attention span of 2.5 minutes, you're on your way to being a genius. And if you've got a 5-minute attention span, you are Einstein or you are Newton. Right? That's what makes them different. They can concentrate for 5 minutes on a problem, and that's what permitted them to do the things that they did. The other lawyer's summation is at least 15 minutes long, isn't it? Well, of course. He's been going for 1.5 minutes. Juror number 3 runs out of attention. What he really needs is a walk around the block. The system doesn't permit it, so he does the next best thing. His eyes take a walk around the courtroom. There's nothing much to see except you, so he looks at you. Now restored, he goes back to listening to the summation. At that point, the next juror runs out of attention. He looks at you, and the next, and the next, and the next. Always assume that at least one juror is looking at you. Make sure that what the juror sees is something you want him to see. Now, I'm not here to tell you funny stories that are untrue. I have never seen a lawyer sitting at counsel table picking his nose or doing something else that's gross. No, I have never seen that. The lawyer sits there invariably in an attitude of respectful alertness. That's, I guess, the right attitude to have. But what very few lawyers pay attention to is what the jurors are looking at as much as you, and that is the table in front of you, and perhaps the chairs ranged alongside of you. You pay attention to things like that. Most of us are wedded to the lawyer's yellow pad. Approximately 1/3 of you are taking notes. Just about each of you taking notes is working on a lawyer's yellow pad. And you know the nature of those yellow pads. If you're going to use them in court, it's going to happen this way. You take notes down to the bottom of the first page. Now you turn it over. Take notes down to the bottom of the second page. Turn it over. Now the first page falls out. About the bottom of the third page, now the second page falls out. So that by the time you get to summations, what you have on the table in front of you is a rat's nest of miscellaneous yellow pads, exhibits, file folders, pencils, pens, the like. And you will tell me that there is no confusion because in a split second, you can pull out of that rat's nest whatever it is you need. I concede you that. You are not confused. It looks confused. That's my concern. When the jury looks over there, to the extent that they say anything to themselves, it's tough case. It's too much for the kid. Look at that, the kid is drowning in paper. They are sympathizing with you, but you are not communicating the Joe DiMaggio effect. That, of course, this ball is going to be caught. There's no doubt about it. Just as you strive to give the opening statement the kind of form that suggests to the jury that you have mastered the case, make sure that the table looks as if you have mastered the case rather than the other way around. Now, so long as you think about it, you'll come up with something. What I like is this. I don't use a yellow pad in court. I try to take no notes at all. None. You're prepared to the nth degree, and then you concentrate as hard as you can. And by the way, I probably won't have time to mention it. I see some of you looking at me unbelievingly. I learned this a long time ago. Especially when the witness is on direct, whom you are going to have to cross-examine. Don't take notes. Look at the witness. You will get much more that way than writing down everything he says. You know what he's going to say, for God's sakes. There's no secret about it. You've already prepared your cross. You look at him Essentially for two reasons. To observe his face, because everybody's face is a giveaway. You see the clouds passing across the face. You get a sense of where he's vulnerable, where you can attack. And you know what's even more important? He must know that you are looking at him. It's the snake and the bird. He's the bird and you're the snake. And you fix him with your steely eye and you don't let him go. You can reduce somebody to a quivering jelly by looking at them in the right way. And that's your job. So, no notes. You must have materials, of course. Use a large 3-holed loose leaf binder. Put everything on 3-holed paper and put it in the binder. And the rule is this: so long as the jury is in the box, you will never open the binder. That way everything stays in the notebook. You use a little arts and crafts sense to figure out how to put into the binder everything that you need that can possibly be fit into the binder. Every document that can be folded in there, fold in there. Now, something, obviously, the murder weapon won't go in there. The empty whiskey bottle won't go in there. But all documents will. And you see, what you strive for is the notebook as a prop. It becomes a prop in the way theater people use props. So that what it communicates to the jury is your total mastery of this case, so total that everything you need is somehow in the magic notebook. You've got a witness on the stand, the policeman. Officer, did you investigate this accident? Yes. Did you look for skid marks? Certainly. Did you find them? You know, I think I did. Did you measure them? Sure. How long were they? You know, I really don't remember. It's so many years ago. Officer, is there anything that might help you to remember? Yes, sir. What is that? The accident report I filed in the station house that night. Out of the notebook. What's that? My accident report. Read it. And do you see, the notebook begins to be a totem object in the courtroom. Everything is in that notebook, and the notebook is yours. Pay attention to who sits with you. Right? On the defense side, you should try to have a client, somebody who looks presentable, you've introduced to the jury, he sits with you. Everything depends upon the circumstances, of course. If he is going to sit with you, almost always my instructions are, don't talk to me. I know a lot of people want the client to talk to you so that the jury gets the impression that he's a human being, etc. That's why I introduce him, but having introduced him, I tell him, don't talk. So long as the trial is underway, once we've passed the point of introductions, I want the jury to focus on me, not you. Because you see, if they focus on me, they may acquit. They're not going to convict me. But let them focus on you, Charlie, and you're going away. Right? So you sit there in a catatonic trance. Don't talk to me. Don't pass me notes so long as that jury is in the box. We'll do our putting our heads together afterwards when the jury is somewhere else. Let the jury see me. If it's a multi-party case, many of you have been involved in that. You're one of several plaintiffs. You're one of several defendants. You all know that invariably the other lawyers on your side of the case are each and every one of them certifiable idiots. Right? And they are methodically going about losing the case. You know that. Right? You've got to worry about them more than you do worry about the opponent. Distance yourself from those other lawyers. It's very important. Every morning, arrive early and move your chair a couple of inches away. If you do it an inch a day at a time, nobody sees it. It's called in the theater cheating. You just cheat away from the others so that by the time you get to summations, you're sitting on the other side of the room. Nobody knows how you got there, but you're all the way over there. So putting some distance between them. You will think that this is a joke. It is not. I have learnt it from masters whom I have seen do it. You're in a multi-party case, and the guys on your side of the case are doing more damage to you than the other side. Typically, you've got a judge who's got a sidebar conference every 10 minutes, right? You've all been in such cases. The judge says, gentlemen, ladies and gentlemen, come on up here. Everybody goes running up there. Why should you? Don't go. Stay in your seat. Stay there. They won't miss you. Even if they do miss you, so what? Have you ever been in a sidebar conference where anything worth talking about got talked about? Of course not. You know what I've seen masters do? They sit there in the chair. All the other lawyers go running up, and they start talking with the judge about the kind of nonsense that they talk about. The lawyer is sitting there in the chair, and then he looks over at the jury. And of course, the jury doesn't know what the hell's going on at the sidebar. And after the lawyer makes sure that he's got the attention of all 12 jurors, he goes, The record is clean. If anybody sees you, I don't know what they can do to you. I mean, it's not really improper. And what it says to the jury is, I'm in your boat. I don't know what they're doing up there. Why am I here? Why is my client here? Let's all go home. Come on, let's go home. We'll leave that. You know, it's that kind of attitude. And little things like that begin to add up. Suppose you're on the prosecuting side of it. Many of us begin to learn the business on the prosecuting side of it. In the U.S. Attorney's Office where I served, the custom was, and it still is, that the case agent sits with the assistant, the FBI agent, the Secret Service agent, or whatever. As soon as I began to get what I thought was a sense of how to try a case, I refused to go along with the custom. I said to the FBI agent, don't sit with me. I'm not going to hide you. You sit in the front row of the audience, and I will introduce you to the jury as one of the cast of characters. But when the jury looks over at counsel table, I want them to see just me. Do you see why? The jury looks over there, and sort of subliminally, what goes through their consciousness is something like, look at that. That kid, 2-3 years out of law school, can handle this case all by himself. He's obviously not very good, but the case is so clear that even he can handle it without the assistance of the case agent or whatever. So clear is the case. That's what I want to get across to them if I'm the prosecutor. Okay. Ideally, when the jury looks over at you, they should in fact see nobody with you or get the impression that nobody is with you. You should be sitting in an attitude of respectful attention, as I've said, but still not tense, relaxed. There's nothing to be tense about. In front of you, that loose leaf notebook, ideally closed. There's no reason to open it. On the table, in addition to the notebook, only one thing, a pencil. A brand new number 2 yellow pencil, sharpened to a brilliant point, placed parallel to the upper edge of the notebook with its point toward the jury box. It somehow looks better that way. I have actually experimented, climbed into the jury box to see which way it looks better. I know, I wanted you to laugh. And the laugh says, does that lunatic mean to say that you win cases because of where you put the pencil on the table? And the answer is that lunatic means to say no such thing. Of course not. But you do win cases by paying attention to every single detail, even such a detail as where on the table you put your pencil. One last point, and we'll move to the last aspect of trial preparation. Obviously, there will be many cases in which you can't put it all in the notebook. You've got 3-dimensional exhibits, a lot of documents, something of that kind. Just think about it. If you think about it, you'll solve the problem. Don't pile it up in miscellaneous form on the table. Get the judge to let you put a filing cabinet in the courtroom. Use a portable cardboard filing cabinet. You can buy them for $5 and throw them away at the end of the trial. Keep it under the counsel table or all the way at the other end so that it seems to be sort of the storeroom, while this end of the counsel table is your study. Do something to make it seem under control. That's the idea, because you want to convey to the jury your mastery of this case. That's always what's involved. Final aspect of trial preparation, it involves executing it in front of the jury, but you execute only after a lot of forethought as to what you're going to do. Now, this is something on which there's been a lot of discussion in the literature and on the lecture platform from people who like to talk about trial practice. In part, I agree with what others have said, but in an important respect, I am in a minority, perhaps a minority of one. I will tell you when I come to that portion of it where my views are idiosyncratic. All I ask you to do is think about it. If you think I'm all wet, fine, you know, go do it some other way. It's this. In what circumstances to use and how to use real evidence? And let me pause to remind you of what we mean by real evidence. And you'll understand when I do remind you that this is what, actually, I guess Melvin Belli began, or not began really, but he was the first to talk extensively about it, and there's a small library of stuff on it. Real evidence, you will recall from your law school course in evidence, is not a witness's account of what happened. It is not a sketch of what happened. It's not a photograph of what happened. It's not a model or some other representation of what happened. It is a piece of reality itself, which is why we call it real evidence. Example, you're the prosecutor trying a homicide case. The witness on the stand is the coroner, the medical officer who performed the autopsy. Doctor, did you perform an autopsy on the body of the victim? I did. In that autopsy, doctor, did you determine the cause of death? I did. Doctor, what was the cause of death? A bullet in the brain. Doctor, I hand you what has been marked People's Exhibit 1 for identification. What is that, doctor? That's the bullet I found in his brain. That bullet is real evidence. It's not the doctor's drawing of it. It's not a picture of it. It's the thing itself. The party line among trial lawyers is that real evidence has enormous impact on the jury, and I fully agree. Real evidence has tremendous impact upon the jury, and what I can add to the discourse is a theory. I have a worked out theory as to why it has the impact that it does, and I'm going to belabor you with that theory in a moment. Now, just to finish the thought so that we can go back and develop it. The party line on what you do with real evidence, given that it has this tremendous impact on the jury, is that you use it as often as you can. That's essentially what Bella and others say. Real evidence should be used 50 times in a case, if you can. My view, idiosyncratic, I may be a minority of one, and maybe I'm wrong, but I don't think so. Real evidence, precisely because it has such enormous impact upon the jury, should be used sparingly. I'm overstating it for effect, but essentially it gets the idea across. Use real evidence once in the course of a trial as a high point. Maybe, ideally, you end with the real evidence. Let me take a couple of moments to sketch out my theory as to why real evidence has the impact that it has, and then I'll be able to explain why I think you should use it sparingly. I have referred 7 or 8 times now to the analogy between courtroom and theater. And every time I think about it, more interesting and fruitful and useful things occur to me. There's something all actors, well, they're aware of it. They really don't think about it. Others have thought about it, and you can think about it too. The next time you are in the audience. Now, Minneapolis has a thriving professional theater, the Guthrie Theater and lots of amateur theater and so forth. I'm sure all of you go to the theater from time to time. The next time you are sitting in the audience, no matter what it is you're going to see, in the couple of seconds immediately before the curtain goes up, take a moment to be introspective. Analyze your own mental state and be aware of how complex that mental state is, the mental state of the member of the audience in the theater with the curtain about to arise. Do you know that what you're going to see is play acting? Yes, it's play acting. It's false. It's not the real thing. These are actors. They are reciting lines they've memorized, lines written by a human being, maybe centuries ago. And what they do has been carefully contrived as a kind of choreography. When Hamlet and Laertes duel at the end of Hamlet, it's not really a duel, it's a kind of dance. And it's something that was conceived by a man writing in 1604, and obviously it's not the real thing. And yet, knowing full well that it's not the real thing, each of us is prepared to accept it as if it were reality. Accept it in the sense that it might even change your life, even though you know it's sham. Coleridge called it the willing suspension of disbelief, and I guess that's the best way of putting it. The willing suspension of disbelief. The audience voluntarily suspends that faculty of disbelief, and you accept it, you believe it, even though you know with your intellect that it's not so. Every actor is concerned with this phenomenon. Something goes wrong on stage. An accident happens. Hamlet and Laertes are, in effect, doing a dance, but somebody slips. Anybody can have an accident, and one actor actually cuts the other. Or how often on stage actors have to have a fight, especially in modern drama. You know, somebody slugs somebody else. Well, obviously, you don't slug them. In the movies, it's very easy to fake. On stage, there's a whole technology to doing these things so that it seems real, though it's not. But what when there's an accident? The actor really hits the other actor. A professional prides himself on his ability to cover it. That's what the actors will call it. You cover it. As a matter of craftsmanship, you don't let the audience see that there's been an accident. Why? Because the actors know that if the audience realizes that what has been play acting is suddenly reality, there's a tremendous impact. The audience really cannot deal with it. It's because the convention has been torn. I willingly suspend my disbelief because I know it's play acting. Suddenly it's not play acting, and I just don't know how to respond to it. When you use real evidence, you are deliberately tearing the convention. You see, you're doing it deliberately. Instead of, here, let me give you an example. If you've spent a lifetime of theater going, watching good professional actors, you are probably unaware of a single accident. You've seen accidents, but the actors didn't let you be aware of it because they covered it. Have you ever gone to an amateur, the High School Dramatic Society? Your son or your nephew, Willie, is in Sidney Kingsley's Detective Story, a play that was on Broadway in the 1940s and is widely used for high school dramatic presentations. There's only one part of it that requires a certain amount of technical skill. The hero, a detective, is supposed to slug a suspect on stage. Just punch him right in the jaw. Well, how do you do it? Just briefly, the way you do it is first, if you know what you're doing. I can talk about it, I can't really do it. The punch is thrown upstage. This is upstage. So that the actor's shoulder really interferes with the audience's view of his arm. As he throws the hitting arm out, he gets his other hand up there so fast that you can't even see it, and he hits his own hand. And of course you can coordinate it so that it goes that quickly. He hits his own hand, and that makes the sound. The actor instantly drops his hand, and the other actor goes, "Ugh!" And you'd swear that he was hit in the jaw. That's if the actors know how to do it. Your nephew Willie doesn't know how to do it. And even if he did know how to do it, he probably doesn't want to do it because he's a mischievous kid. So instead of getting his hand up there and hitting his own hand, he slugs the other kid right in the nose. And you're sitting in the audience, and suddenly the other kid has a nosebleed. And if you've ever been in the audience when that has happened, you will know that your distress is infinite. You are beside yourself. Even though with the intelligent part of your mind, you know that the kid has a nosebleed. In the last 6 months, he's had 50 nosebleeds. He's going to have another 50 in the next 6 months. In 30 seconds, he will be as good as new. There is nothing to worry about, and yet you are distraught. Why? Because the convention has been torn. Play acting suddenly became reality. And when you put real evidence in, you are doing it deliberately. That's why it has the kind of impact that it has. Many of you have been involved in cases where the real evidence was of that sort. Doctor, I hand you Plaintiff's Exhibit 1 for identification. What is it, doctor? That is the bullet I removed from the victim's brain. Your Honor, I offer it in evidence. And now, Your Honor, may I pass it among the jurors? Have you ever tried to pass that among the jurors? They won't take it. They won't. They're afraid that it's still sticky with the brain tissue of the human being whose death it caused. And even if you were to reassure them that it's been washed off, they still won't touch it because it's a kind of juju object. It's a metal slug that caused a fellow human being to die. That's precisely why the prosecutor puts it in. Have you ever been in a heroin case? This is a real case. I was one of assigned defense counsel in it. You know what the prosecution had? 50 pounds of pharmaceutically pure heroin. It was a conspiracy to import narcotics, and on this occasion, boom, they grabbed the whole bunch of them. With that shipment, 50 pounds of 100% pure heroin. That's not the kind of stuff you make with a Chemcraft No. 5 set in a basement in Marseille. I'll tell you where it was made. It was made in a chemical factory on the mainland of China and deliberately sold for 50 cents a pound to the bad guys so as to get it into the United States in order to subvert the social fabric of the United States. That's what was going on back in the early 1960s. 50 pounds of pharmaceutically pure heroin diluted down to street strength. Do you know what the value of that stuff is? You can buy an Air Force with it. That's how much it's worth. And the government walks in with 50 pounds of this stuff in heavy plastic, sealed the way you seal a toothpaste tube because machinery was used to make it. And they dump it into the jury box, and the jurors go right up the back wall. Ah! I don't want to touch it. They're afraid they will become instantly addicted. That's the impact it has because the convention has been torn. And that's why you use it sparingly. Do you see why? Back to Joe DiMaggio and my view of how you try a case. If you use it once, it's a hand grenade going off in the courtroom, and they do go right up the back wall, and that's a wonderful point at which to say, Your Honor, the defendant rests. Do it a second time, the hand grenade will go off. A third time, the hand grenade will go off. A fourth time, I guarantee that by the fourth time, somebody on the jury says, wait a minute, this is being done deliberately. We are being manipulated. This is showmanship. Of course it is. But it must be the showmanship that conceals showmanship. Let one juror say, this guy is just putting on a show for us, and you have lost the case. They will admire it, they will be titillated by it, but they will not trust it. And that's why you're going to lose the case. And that's why my advice is to use real evidence sparingly. Before we leave real evidence, though, whether you use it once or whether you use it 50 times, there is yet another aspect that I want to talk about. When you put real evidence in, the jury knows that they cannot put it into words, that this is the kind of thing a trial lawyer is supposed to know how to do with square corners. This is fielding a routine fly ball if you're a center fielder. It's making the kind of incision, if you're a surgeon, that can be sewn up, leaving an almost invisible scar. You know, it's just mechanical skill. You don't have to be a great creative genius to do it, but you've got to know how to do it. That's what the jury expects of you when you put real evidence in. You must do it so that you look like DiMaggio playing center field. If you don't know how to do it, you will probably manage to get it into evidence, but you will not have impressed upon the jury your professionalism, the kind of professionalism that leads them to trust you. Now, I think I can be helpful here. Again, you won't find this in any book or in any case, but I'm sure that it's right. Insofar as Wigmore or McCormick or somebody like that gives you the evidentiary basis for putting real evidence in, it's very easy. Real evidence is admissible if the proponent, the lawyer who wants it in, proves that it is the real thing, subject to the judge's discretion to exclude it if it's unduly prejudicial, inflammatory, surprising, or confusing. End of discussion. It occurs to me, and I'm positive that it's right, that there are only 3 ways of proving that something is the real thing, any one of which suffices. And the way to look like DiMaggio is to determine in advance which one of these ways you are going to use, using it and stopping. When you go ahead and you use 2 of the 3, or all 3 mixed together simultaneously, that's when you look like a bumbling amateur. What you want are square corners. That's a term musicians use. It means playing a chord so that it begins and ends with a ping instead of being sloppy at both ends. What are the 3 ways? First way, you don't run into it very often, but we've got to understand it because we will build upon it. The piece of real evidence, whatever it may be, is by its nature unique. There is only one of them in the world. Do you know how you get it in? Call a witness who says, that's whatever it is. There's only one of them. That's all you need do. In it comes. Example, drawn from a real case. When I was in the U.S. Attorney's Office, prosecuted a charge of interstate transportation of stolen property. Terrific case. The defense was temporary insanity. The property was a Degas, a late Degas, almost the size of that blackboard. Hideously ugly. Not because Degas isn't a great painter, he is a very great painter, but he purposely made it hideously ugly. It was late in his life, he was getting kind of bitter, he was short of money, and a banker named Augustine said, I will pay you a great deal of money if you will paint a picture of my wife, my 2 kids, and the dog. So Degas painted the picture, indicating that he hated himself for taking the money, he hated the banker, he hated the wife, he hated the 2 kids, and most of all, he hated that dog. And all you had to do was look at the painting to know it. That's the picture that had been stolen. The FBI recovered it in Texas, brought it back to New York. Right? The case went in so that everything about the theft, transportation, etc., had been proved, but the picture itself was not in evidence. And here's how we handled it. The jury box was over there. On the facing wall, a colleague who was a skilled amateur carpenter had built a huge stand. And we put the picture on that stand, and I went to the 5 and 10 and with my own $3.50 bought a triple bed-size bed sheet, and I covered the painting with the bed sheet. And when the judge said, "Younger, why are you covering the picture with the bed sheet?" I said, "Well, Judge, it's not in evidence yet, so the jury can't look at it." "Oh, right, right." So the jury sat there throughout 3.5 days of trial, staring at that bed sheet. And of course, by the end, they couldn't contain themselves anymore. It was coming out of their ears. What's under the sheet? I saved it for the last witness. And this, almost verbatim, was the testimony of the last witness, the witness who gets the picture in. Now remember, other witnesses had supplied relevance, so it's just getting the picture in. I'll give you his name and all the rest of it. "Sir, take the stand." "What is your name?" "Theodore Rousseau." "Mr. Rousseau, what's your occupation?" "I am the curator of modern European painting at the Metropolitan Museum of Art." Mr. Rousseau, would you step down, with your Honor's permission, would you step down and go over to whatever it is that's behind the bed sheet? Don't remove the bed sheet. Just go over there. "Yes, sir." Mr. Rousseau, without removing the bed sheet, would you look under the bed sheet? Now, Mr. Rousseau, resume your place on the witness stand. Mr. Rousseau, did you recognize what is under the bed sheet? "Yes, I did." "What is it?" "Degas' painting of the Augustine family." Now, footnote, I didn't say this. Do we recognize that a painting is unique? Yeah, this is not a reproduction. This is the real thing, right? That is Degas' painting of the Augustine family. Your Honor, I offer it in evidence as Government Exhibit 10. Received. And now, Your Honor, since it's in evidence, may I remove the covering? Please. Shh. And from the jury box. That's ugly. Your Honor, the government rests. Bang. And that's that. It's not often that you deal with a Degas painting, something which is by its nature unique. More commonly, you deal with something which by its nature is not unique, but the witness on the stand did something to it which makes it unique, such as he put his initials on it. He put a mark on it of some sort. All you need do then is establish what was done to this thing to make it unique. And you see that sort of puts you back in the first way. It's now unique, though man-made rather than by its nature. And all you need do is establish what it is that makes it unique. Nothing else is necessary. Example, officer, an assault case of some kind. Officer, did you remove the beer bottle from the hand of the defendant? The beer bottle was the weapon. Yes. I hand you what has been marked Commonwealth Exhibit 1 for identification. What is that? That's the beer bottle I removed from the defendant's hand. Now, wait a while. A beer bottle is not unique. There are a million Schlitz beer bottles floating around. So we need the next question. How do you know that that's the beer bottle you took out of the defendant's hand? Because when I took it away from him, I wrote on the label my initials and the date, and there they are. You can see them. I offer it in evidence, and in it goes. Third, the object is by its nature not unique, nor did the witness do anything to it to make it unique. So you know what we have to do? Just look at it logically. Here we are on trial. An object will be produced in this courtroom. We contend that this object is a piece of the reality that figured back then, when the transaction took place which constitutes the subject matter of the lawsuit. How do you prove that? If the object is neither unique nor was it made unique, you trace it through time. You get from then to now, or now to then, but you simply track it through the days, weeks, and months between the transaction and today. And what do you call that? The chain of custody, sometimes called the chain of possession. You need it only when the object is neither by its nature unique, nor did a witness do something to it to make it unique. Officer, did you remove the beer bottle from the defendant's hand? Yes. What did you do with it then? Now, we know he did not mark it in any way. Well, I took it back to the station house. What did you do with it in the station house? I put it in the lower left-hand drawer of my desk. Do you share that desk with anybody? No. Does the desk have a lock and key? Yes. What did you do that night? I locked the lower left-hand drawer. What was in that drawer again? The beer bottle. Did you open it from that night any time up to this morning? No, sir. To your knowledge, did anybody else open it? No. Did you open it this morning? Yes. When you opened it, what did you see? The beer bottle. What did you do with it? I brought it to court. You mean it's here in court now? Yes, sir. Where? Well, it's in my briefcase. Where's your briefcase? Right here on the floor, next to my foot. Pick it up. Open it. Zip it. Reach in. Take out whatever you feel. What's that? That's the bottle I took from the defendant's hand that night in the bar 6 months ago. Your Honor, I offer it in evidence. Do you see how we've traced it through time? One of the three, use it and then sit down, because any one of those three will suffice. Which brings us, about on schedule, to the subject of direct examination, on which I think we've got time for me to say what has to be said. And I do it with some fear and trembling, ladies and gentlemen, because direct examination is a very difficult topic to discuss, just as it's a very difficult thing to do effectively. If by direct examination you have in mind the reasonably protracted direct examination. And by reasonably protracted, I mean anything on the order of 15 minutes or longer. That's long in the courtroom. So if it's going to be 5 minutes or so, I have nothing to say. But if you are conducting the direct of the plaintiff in a heavy personal injury case, if you're conducting the direct of the chief executive officer of a large corporation being sued for antitrust violations, well, that's not going to be 5 minutes, that's going to be hours, maybe even days. Many of you have engaged in such direct examination. You know what you want it to be. You want it to have forward motion, impetus, rhythm, irresistible progress. And the contrast between what you actually do and what you'd like to do is so great that it sometimes makes you want to throw in the towel and give up and go find some other way of earning a living. You know what it's like when you conduct one of those protracted direct examinations. It's so lacking in rhythm and impetus. Something like, so what did you do? Blah, 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 blah. And then what did you do? Blah, 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 blah. And what did you do after that? Blah, 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 blah. Yeah. Just hard to stay awake, let alone sweeping everything before you with the inevitable forward rush of that direct examination. Let me, I've already used theater, I've used literature, I just used art. I will now go to music. Suppose I were to take advantage of you as a captive audience and say, ladies and gentlemen, I have just completed my new symphony. It is my 5th in C minor, and I want to sing you the opening 2 measures. Now, I can't sing. You'll forgive the composer's croak, but I want you to hear it. Are you ready? Here it is. The first 2 measures of my new Symphony No. 5 in C minor. Ba, 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 ba. Yes. And of course, there's a kind of nervous laughter, and I intended there to be nervous laughter, because that's no symphony. That's not music. It's not even noise. It's nothing. It just lies there in the bowl. It doesn't even sop up the milk. That's how nothing it is, right? Suppose, however, I were to announce to you that I have completed my new symphony. It is my 5th in C minor, and confident that you will forgive my composer's croak, I propose to sing to you the first 2 measures. Are you ready? Here we go. Ba-ba-ba-bum. Hey, that's good. That's good. What's the difference between that and what came before? Well, one difference is that is Beethoven, and what came before is Younger. But at a somewhat more profound level, what is the difference? And the difference is obvious. It is so obvious that one has to force oneself to say it, but it's the secret of all music, of all dance, and perhaps indeed of all art, because it gets right down into the blood system and the central nervous system and the DNA quivering within us. The difference is rhythm. That's what. The thing I did was totally arrhythmic. What Beethoven did was pluck out of the air, as it were, that most famous rhythmic segment in all of Western music, the 3/8 notes and the protracted half note, the V, you know, ba, 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 bum. And while in a million years he couldn't put it into words, Beethoven, knew something about the way the central nervous system operates. And we've got to learn that too, because it's the secret of an effective, lengthy, direct examination. And you know how to put it to the test? I doubt that there's anybody in the room who has never heard the Beethoven Fifth Symphony. But listen to it again sometime soon and try to hear it for the first time. Close your eyes and listen to the first movement. When it's over, ask yourself about how long it took. And if you can really hear it as if for the first time, your answer, I guarantee, will be that it took something on the order of 30 seconds. It goes like greased lightning. Talk about forward motion. It's over before it starts. And now look at your watch. The first movement of the Beethoven Fifth is longer than any complete symphony of Haydn or Mozart before. Depending upon the performance and whether they take the repeats, it can be as long as 32 minutes, and it seems like seconds. When you conduct a 32-minute direct examination, you want it to seem like seconds. Most of the time, it seems like hours, of course. What's the secret? The secret is what Beethoven knew. Beethoven knew that the way human beings respond, the way the central nervous system responds, is something like this. Every one of us has a limited attention span. When that attention span is used up, we just can't listen anymore. It's gone. What we need to have done to us is winding up the key, restoring the attention span. And you know what restores the attention span? Well, Beethoven was making music, so I'll use his term, sound. You use up the attention span by directing at the audience a long note. Ba. And the way to wind up the attention span is to give them short notes then. Ba, ba, ba. That winds it up. Now you've got it again. Ba. Now wind it up again. Ba, 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 ba. And there's a kind of double effect. The short notes, the winding up, prepare the listener to give you the attention span, which is the aesthetic miracle of that rhythmic segment. Ba, 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 ba. That's all it is. But you see, the short notes prepare the attention for the long one, and then when the long one has used up the attention, the next rhythmic segment turns the key once more. Ba, ba, ba. And here we are. Bum. Which is why that just unbelievable first movement. Do you know what it is? I forget the exact count. It's been counted. 527, if I remember correctly, repetitions of that rhythmic segment. That's just 500 some odd times it goes ba-ba-ba-bum, with some contrast from the second theme. That I can't sing it, but you all know what it is. And somehow the thing goes, as I say, like greased lightning. That's the secret of a direct examination. You can't do it with mathematical precision. You can't do it with musical precision, but to a very great extent, you can do it sufficiently so that the thing has some pace, some forward motion. You construct your direct examination, as nearly as may be, so that it is a series of rhythmic segments, each segment consisting of a number of shorts, not necessarily 3, but 2, 3, 4, 5, whatever. Ba, 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 ba. And then a long. Ba. And then as quickly as you can, get back to another rhythmic segment, which is shorts, followed by a long. Now, you won't always be able to get right back to it. That's why you can't do it with musical precision. But you try. What's the courtroom equivalent of Beethoven's eighth notes, the shorts? Questions like, were you there? Yes. Was it 10 in the morning? Yes. Was the sun out? Yes. And what's the courtroom equivalent of Beethoven's extended half note, the long? A question like, what did you see? What happened then? What I'm saying is that the secret of an effective direct examination is the adept use of leading questions. Because a leading question is your short, and you use 2, 3, 4 of them, and then you follow it with a long. At this point, one or more of you will wish to rise and denounce me. You will want to say, but I learned in law school. Nay, it's the only thing I learned in law school, that you may not ask leading questions on direct examination. And here I am telling you that the secret of a good direct examination, in my view, is the adept use of leading questions. Well, I learned the same thing in law school, and from time to time I teach it. You may not ask leading questions on direct examination. That is so. That is the rule. But there are exceptions. If you look at Federal Rule 611C, it says no leading questions on direct, but the judge has the discretion to allow leading questions, and that's much too general to be helpful. When it dawned upon me that from the point of view of trial advocacy, leading questions on direct examination were enormously important, I went to the books, and I discovered that there are no fewer than 10 separate, universally recognized exceptions to the no leading question rule, at least 8 of which can be anticipated. If you can anticipate them, you see what you do? You deliberately lay the thread of your direct examination in such a manner that as often as you can possibly bring it about, you are within the ambit of some exception to the no leading question rule, so that you may, with perfect propriety, with perfect honor as a lawyer and an officer of the court, ask leading questions. Now let's run through these 10 exceptions, and I'll give you the examples as to some of them to show you how you can use it to give that wanted impetus or forward motion to your direct examination. It's all in the materials, by the way. First, as to preliminary matter, you may lead. Everybody knows that. What I add, will I add perhaps to your understanding, is that preliminary matter comes not just at the beginning of the direct, it comes over and over again in the direct. Every time you come to a new paragraph, as it were, there will be preliminary matter at the start of that new paragraph. Develop it by leading questions. Not meaning to be realistic, but just to give the hang of it. Sir, were you standing on that street corner? Yes. Was it 10 in the morning? Yes. On May 5th, 1979? Yes. Did you have a good view of what happened? Yes. Did you see what happened? Yes. Tell the jury what happened. There's the long, and they can't wait for it because of those first 5 or 6 leading questions. And that's preliminary matter. You may ask leading questions. The law of evidence says that. You should ask leading questions. The craft of advocacy says it. Next, you may elicit uncontroverted facts by way of leading questions. A fact that is uncontroverted will usually be determined by looking at the pleadings. Everybody knows that. What's admitted? I go beyond that. There is an insufficiently appreciated discovery device available in all states and in the federal court. It's not really a discovery device because you can't discover anything with it. It's a way of preparing for trial. It's the notice to admit or request for admissions. You all know what that is. You send the other side a list of facts which you say in good faith cannot be disputed. If the other side is playing by the book, they will admit what cannot rationally be disputed. I put it to you, you all know this, in every lawsuit, no more than 10% of the facts will be in dispute. A lot of lawyers like to play it so that they dispute everything, but if you look at it, just a few facts are in dispute, not everything. Use the notice to admit. For what end? To remove facts from controversy. You know why? So that you can then elicit those facts by leading questions, hence giving your direct examination the pace that you want it to have. An example, and I put it to you that every one of the leading questions I will ask can be supported by an admission you obtain by using a notice to admit, and if the other side is playing the game the way it's supposed to be played, they will give you that admission because there's no dispute about it. You left your apartment about 10 in the morning, didn't you? Yes. You came out on the street? Yes. Your car was parked at the curb? Yes. That car was a yellow Plymouth? That's right. You got behind the wheel? Yes. Started up? Yes. Moved about 100 feet to the intersection? That's right. The light was green in your favor? Yes, so. Did you put your right turn signal on? Yes. Did you begin to make a right turn? Yes. Did something happen? Oh boy, did it. Tell the jury what happened. What happened will not be admitted and shouldn't be admitted. All of those preliminary things should be admitted in response to a notice to admit, and that's how you begin to fashion an effective direct examination.